Yesterday, a free judge bench gave two decisions in one. It is a mongrel of a judgment. In this matter, the judges were politicians. They were not 100% judges, but they shot themselves on the foot when they also confirmed that Gachagua's being denied a chance to be heard violated the constitutional provisions. They know very well that Gachagua will be in the ballot come 2027. Nobody will stop Gachagua from being in the ballot in this matter. Suppose the judges said Gachagua was wrongly impeached and he should go back to the office. This country could explode into a war. This clearly sets the precedent that we can impeach presidents. This is the Solomonic wisdom to keep the country at balance. Welcome to Court Helicopter trending version of our explainers. Yesterday, a free judge bench gave two decisions in one. Why am I saying there are two decisions in one? They balanced. It was a jurisprudence of balancing, where you cannot know exactly what the judges were saying. Kenyans have been thrown into a spin. They can't get the head and the tail. It is a mongrel of a judgment. And we have looked at Court Helicopter the whole night. We watched the news as it was unfolding. Very critical things come out of that judgment. One, they found out that indeed the impeachment of Gachagua was valid. Nobody disputes about that one. But they shot themselves on the foot when they also confirmed that Gachagua's being denied a chance to be heard violated the constitutional provisions. Then they went further to say, this constitutional violation which we have established, Gachagua will give you 50 million. I think that is pocket money for Gachagua. 50 million is nothing for Gachagua. Gachagua's price is bigger than that. Did you listen to everybody? All the petitioners were saying they have already filed a notice of appeal. Why were they filing a notice of appeal even before the decision had come? These are lawyers, serious lawyers. They looked at Article 99, free of the Constitution. Why were they looking at Article 99 of the Constitution? They know very well that Gachagua will be in the ballot come 2027. Why is Omari and Vivian from Court Helicopter bringing a confusion like the judges have done it? No, it is not us. Article 99(3) says a person is not disqualified under clause 2 unless all possibility of appeal or review of the relevant sentence or decision has been exhausted. Gachagua knows this very well, that so long as there is an appeal at the Court of Appeal, or so long as there is an appeal at the Supreme Court, Gachagua is going to be validly on the ballot. Nobody will stop Gachagua from being in the ballot in this matter, unless the Court of Appeal sits next week, determines the matter, it goes to the Supreme Court in 2 weeks' time or 3 weeks' time, and determines the matter that Gachagua was validly impeached. The Simon Makonde story is what can make Gachagua not to be in ballot. So we also looked at, why is it that denial for somebody to be heard is such a serious issue? We looked at the law and found out Article 25. What does Article 25 say? The fundamental rights and freedoms that may not be limited. These one, you cannot limit them. These rights can never be limited. 1, the freedom from torture and cruel, human or degrading treatment or punishment. That one, you cannot limit that. Freedom from slavery and servitude. You cannot write that. Free, the right to an order of habeas corpus. C, which is very critical for Gachagua, is the right to a fair trial. You can never fail a Kenyan by not giving him a fair trial. Article 50 of the Constitution provides equally. That is Article 52 says every accused person has the right to a fair trial. A fair trial. Gachagua had a right to a fair trial. Article 51F says every accused person has a right to be present when being tried, unless the conduct of the accused person makes it impossible for the trial to proceed. Gachagua had a right to be present. He was in hospital. He never caused noise in the Senate. Had he caused noise and became a problem, then he could have been excluded from the Senate. So these rights are so fundamental that you cannot deny Gachagua this chance. And that is why Court Helicopter went further to understand what is the political angle the judges took. In this matter, the judges were politicians. They were not 100% judges. Is it really legal for judges to be politicians? No. This is a political process. This is a constitutional process. You heard the judges say in America, in other countries, impeachment cannot be taken to court for determination. But in Kenya, it is an issue that can be dealt, that must be dealt with the courts of Kenya. 2007, Kenyans slaughtered each other in the post-election violence. Raila Odinga versus Mwai Kibaki election. Raila Odinga was with William Ruto. The Pentagon. Kibaki beat them. But they had more MPs. War erupted. 1,000 Kenyans, over 1,000 Kenyans died. Over 600,000 Kenyans were displaced. And that's when we found in IDPs, internal displaced children and internal displaced people. Many women were raped. It was a big issue in this country. The government set up the famous Waki Commission, the commission to investigate this matter. Justice Waki Philip recommended setting up a local tribunal. It went to Parliament. Parliament said, no, we are not going to set up this tribunal. You remember the late Otieno Kajwang and the others. They said, there is no need to set up this tribunal. Waki gave a secretary envelope to then Secretary General of the UN, Annan. Annan gave the secret envelope to the ICC. ICC's prosecutor, Luis Moreno Ocampo, opened the envelope, and there were 6 Kenyans free from PNU and free from ODM. Kibaki's wing, there were 3. From ODM, Raila's party was William Ruto, the broadcaster, news, a man of the media, Joshua Arap Sang, and also we had a person called Henry Koskei. They all went to the ICC. Balancing act. Is this the magic the three judges did? Yes. They gave Ruto and Kindiki one side, 50%. Kindiki, you were given the job rightfully. 50% of the judgment, they are celebrating. 50% of the judgment, Gachagua, take your 50 million. So this was a balancing act, as we have told you. Judges have got to balance. They listen to the country, the pulse of the country. Suppose the judges said Gachagua was wrongly impeached and he should go back to the office. This country could explode into a war. Suppose they said Gachagua, there was nothing wrong that was done to Gachagua. His DCP region, the Mount Kenya region, could have exploded into war. This is the Solomonic wisdom. To keep the country at balance, just like Waki kept the country at balance. But does this judgment have any jurisprudential capacity to stand at the Court of Appeal? I don't think this will stand at the Court of Appeal. But will it be determined before 2027? It is likely to be determined after 2027. What will be the net effect if this determination comes after 2027? The politics of 2027 would have ended. There, we are likely to get a decision that will be resounding that Gachagua was wrongfully impeached and therefore his position that Kindiki sits is academic. That will be after 2027. No judge will make that decision today because of the politics and the 2027 elections. What comes out very clearly is that it is very easy to impeach President Ruto or any other president who is in this country. The judges made it very clear that the only provision not available in law is a provision for the impeachment of the deputy president. So for the president is a fait accompli. The procedures are there, the constitutional provisions are there. But the judges goofed. They clearly said the impeachment of a governor is a statutory process provided by the County Government Act. But the impeachment of the president and the deputy president is a constitutional provision. As I've said, the judges were not ready to hurt the country. They were walking on eggshells to keep the country intact. But what am I saying? The President of the Republic of Kenya, William Ruto, or whoever comes, this clearly sets the precedent of that we can impeach presidents and we can impeach deputy presidents, we can impeach governors, the law being settled. Has it ever happened again? Yes. In 2013, in 2017, where Raila Odinga was in the Supreme Court, the country was like this. They believed Raila Odinga won the elections. When this matter appeared before Maraga and the Supreme Court, the country was waiting to tear itself into pieces. Maraga and the Supreme Court listened to the country and nullified Uhuru Kenyatta's election. After the nullification, the country pulled to a halt. The country's adrenaline had gone up. Yesterday, the country's adrenaline was up. bright judges listened. I'm definite there was an input from the National Intelligence Services, because the country, if this was a winner takes it all, where they are saying you won, the other lost, this country, Kenya, could not be together today. Today, we are enjoying happiness. Look at Gachagua in church. Gachagua foresaw this, and they told the people, whichever decision that will come, we will go to the Court of Appeal. He appeased his Mount Kenya region. He appeased his people. And that is the quality of a statesman. Wakili Danstan Omari, bringing it to you all the way from the archives. And we wish to thank our crew for good research, Vivian, because this one is only available in Court Helicopter. Thank you.